Good evening, everybody. I hope you are all doing well. Today is February 4th, 2026. I hope it is warm where you're at. Here in Atlanta, it moderated a little bit this past weekend, was brutal. I think it didn't get over 32 degrees the entire weekend. And for us down south, that is really, really cold. And it's been chilly, but I think today hit mid 50s. It's going to get a little cooler the rest of this week, but I know a lot of places in the country had ice storms and all that, so I hope that you are all safe. So anyway, again, I hope everybody's doing well. And what we're going to do now is I'm going to answer a few questions that have been people posted ahead of time. Then I'm going to do something a little bit different. Thought it'd be kind of interesting to go to ChatGPT and ask it some questions about Social Security, and I'll give you my take on whether the answers are good or not. Some of this is going to be done kind of live because I just took a quick look, but we'll see what that comes back with. But anyway, let's go ahead and answer some of the questions we've already got there here. Tom is one of my clients. We had his hearing last week. It will be an approval, a favorable decision. And he had sent me a couple of questions and he said, thanks. And it looks like everything looks good. And was I satisfied with his testimony? And Tom did something very smart. And what he did was, I'd send him a list of questions he was likely to get. And I do that just so you'll have an idea of what my clients will have an idea what the questions will be. Although you don't want to necessarily write out answers and read. That doesn't seem natural, but you can make some copy points. And in his case, English is not his first language, so he wanted to kind of sketch it out a little more. So he sent me his answers, and they were actually quite good. And what he did was he was very, very clear about specifics, how long he could sit or stand or walk. You avoid not very long, not too far. 10 minutes, 15 minutes. And all this are things that we had discussed in our pre-hearing call, and he had taken notes. And so he had that in front of him. And I think that's a smart thing to do because realize, when we have our pre-hearing call, it's pretty relaxed. It's me and my client talking. But, you get in front of a judge, even though it's a telephone hearing, you're going to be a little bit nervous. So, you might forget, not that you want to, recite exactly everything that you had told me before, but you want to have a pretty good idea. Examples would be one of the questions I'm always going to ask in a physical case: how long can you stand? How far can you walk? How much can you lift? And my experience is that people sometimes overstate what they can do. I could walk for about 2 hours. Really, 2 hours is a long time to be on your feet. I don't know that I could walk for 2 hours. Lifting, people, I can lift 50 pounds. 50 pounds is a lot of weight. And if you've got, back issues or shoulder issues or elbow issues, 10 pounds might be a problem. So, these are the sort of things we go over in a pre-hearing. And it's not a bad idea to have that kind of sketched out so that if your mind goes blank, you can look down and you first of all, you practice it ahead of time and just keep reviewing it so you know how you want to answer it. And again, it's got to be truthful, but you want to have it in front of you. So in case your mind goes blank, you can look down and yes, 10 pounds, 15 pounds, 10 minutes, and not sort of revert to what you used to be able to do or what you think you'd like to be able to do. And once you say it, and then 2 minutes later, you realize, I screwed up. It's kind of hard to go back and undo that. So that's one of the things he did really, really well. He wrote out an elevator speech. Why do you feel you're disabled? Again, very, very clear. And 2 or 3 sentences. Not every judge asks that, but some do. You want to have that ready. So, I think that he did a really nice job in answering the questions very succinctly. One thing he also did not do, which was good, he didn't ramble. I sometimes have people want to tell their life story. So I fell off a truck when I was 15 years old. Well, the problem is you work for 25 years after that. It's kind of hard to argue that, that injury 25 years ago would be something that would prevent you from working now. So again, just realize what judges are looking at. Most judges would tell you, I think, that they're trying to get a sense of what your average day is like. They realize that you're going to have good days where you feel really good. You might do more. You could do some yard work. You might go shopping. And there are going to be some days when you can barely get out of bed. So what you want to think about when you come up with your answers to questions and you're thinking about your testimony, pick a day, not the worst day. So again, if your days are, 1 to 10, 1 being I can't get out of bed in the morning, 2 being I am, 10, I'm sorry, 1 being I can't get out of bed in the morning, 10 being I feel great, I could tackle the world. Pick a day that's a 4, not right in the middle, maybe just a little bit less than right in the middle, but towards the not so good. That's a pretty good average day. And, think about the things you could do and you couldn't do. You don't want to exaggerate. You don't want to say my pain is at a 10, 24/7. Judges are not going to believe that. But it's more believable to say my pain is always at a 5 or a 6. It will spike up to an 8 or 9, 3 or 4 days a week for 2 or 3 hours. And I've got to take, hydrocodone and it puts me to sleep. That is a little more credible. That's more believable. So that's the sort of thing that you want to really think about. And that's what we go over in our pre-hearing. And Tom in his testimony did a really good job. It wasn't a back pain case, but in terms of his impairments, he was very, very clear about the frequency, duration of the issues that he's been facing. And I think that he came across as being very, very believable. I think the judge liked him. I think the judge felt like he was telling the truth. And I think that, judges are human beings and they have a sense of when somebody's, feeding them a load of BS and when somebody's telling them the truth. And when you say something like, I really enjoyed what I did. I was making a good living. I had a lot of friends there. Since I haven't been working, I don't really interact with people very much. My family is getting upset with me because the money's tight. You're telling a story. We're hardwired as human beings to tell stories and to listen to stories. And so it's really important, I think, to tell your story and tell it in a believable way. You want to go in there as a reluctant claimant, not as somebody who feels they're entitled. You don't want to be here. You'll go back to work as soon as you're feeling better, if you feel better. And you just tell your story that it's unfortunate these things happen to you. You're doing your best. You're trying everything the doctor is suggesting, but there's certain things that just, medicine can't cure at this point. You got 4 herniated discs and you've already had 1 surgery, it didn't work. Pretty good chance that you're not a surgical candidate. Scar tissue is formed. There's probably not a lot that can be done other than long-term pain management, which some people decide they don't want to do because they don't want to get addicted. So they deal with it by just limiting their activity. Other conditions, you have a bad heart problem, congestive heart failure, your heart's, your heart's pumping capacity is greatly reduced. You have chronic venous insufficiency. There's not a lot you're going to be able to do. This is just one of those things. So, you make the best of it, but those are the sort of things you just sort of tell the judge, this happened to me. It wasn't my fault. And I'm, I wish it didn't, but it did. And so I'm doing the best I can, given the cards that have been dealt to me. And so that's the way you approach it, I think. And Tom did a really good job in just presenting himself as a sincere, but unfortunate person, and that some things happened to him that medically that were unexpected and wasn't his fault. There's nothing that can really be done. And so he's trying to gradually get better, but it's a long road. So he did a really good job. But I think the biggest thing he did well was very, very specific, talked very specifically about time, distance, duration, things like that. And the second thing is he sort of had his notes in front of him so that he didn't read it, but he had it in front of him. So, if mind goes blank, and it'll happen, he was ready to, just look down and kind of answer. That's one nice thing about telephone hearings is that you don't have to be looking at somebody. You can have it right in front of you. And again, I don't recommend you write it all out, but you can have copy points. Look, that's the way I do my videos now. When I do a video for Social Security, I write out my copy points, 3 or 4 copy points, maybe a couple other things I want to discuss. I don't read it. I don't have a teleprompter. You just talk and you're sort of talking one-to-one. And that's the way you do it at a hearing as well. So anyway, I appreciate it. And Tom said, thank you we have a good staff, and I appreciate your kind words. Thank you. And I just checked. I know we emailed today. His case is in post-hearing review, which basically means that the judge has made the decision, has sent it out to the decision writer. The decision writer is kind of putting together his outline to write the decision as if you heard one of my live streams with Spencer Bishens, who's going to be on at some point later this year, he used to work for Social Security as a decision writer as part of what he did. He said actually favorable decisions take longer to write than unfavorable because the decision writer has to go through the transcript, has to find the evidence, has to support a favorable decision because, again, judges are putting Social Security on the hook and they're being reviewed. So the judge has to be more careful about that as opposed to an unfavorable decision. So there we go. Rodney, one of my longtime clients of my firm, good evening. He's a regular here. Good to see you here. Kevin, thank you very much, Kevin. I really, really appreciate that. As I mentioned, my son, Jake, who does a lot of my video work, we go to lunch with these tips, and I really appreciate it. We went to lunch the other day, and I told him, I said, you can thank my loyal live stream visitors because they're paying for it. And he was very grateful for that. And I really appreciate that, Kevin. And I think you said some nice things. I'm a Kung Fu Panda. I don't know if anybody's ever called me that, but okay, I'll take it. And he said, he got a fully favorable decision. That's awesome. I'm the GOAT. I don't know if I would say I'm the GOAT, but I appreciate it anyway. And as I said, thank you very much. And I really, really appreciate that. Very, very nice of you. Choice by Choice says, I finally received the judge's decision, fully favorable on the record. I'm in Wisconsin. My question is how long for the back pay and the monthly checks to start? Is there a number or email to check? Okay. So generally when you receive a fully favorable decision, that's great. That you're in the home stretch now. What will happen is the case will be sent to a payment center for what they call non-medical review. And I'm talking about an SSDI Title II disability case. And they just need to check to make sure there's no earnings after your onset date. In other words, that you were not working and they didn't know about it. And that process can take as little as a week. It can take 3 or 4 weeks. Now, I will tell you that money processing has been extremely slow. In January, I think I got like 2 or 3 payments. I mean, very, very slow. And I had a bunch of favorable decisions that I'm still waiting on. Getting decisions out has been slow. I'm not sure if it's just lack of staff or they had a kind of a lull over the holidays, but it's been really, really slow. So, although on the other hand, I had a case that I tried in January and the money was deposited in my client's account and in my bank account within, 2 weeks. So it can be very quick. It just depends on, the office that's dealing with and if there's any complications there. But hopefully it won't take very long. But there's not really anything you can do. You can look at your My Social Security account. That may give you some information. But, there as far as the numbers to call, there is the people that do the money calculations. They're called, the office they work in is called the MODS, MODS, and stands for modules. And the MODS are basically people in the payment centers. One of the things that as an attorney that we do sometimes is when money's not coming when it should, we'll call the MOD, we'll call the payment center. I will tell you, they are really hard to get a hold of. One of the things they do is they change their numbers periodically. It's hard to track down where the numbers are. Now, NOSCR, which is our trade association, national organization, Social Security claimants reps, and there's a couple other ones out there now too. But they're usually pretty good about giving us updated numbers. And basically, you'll have a certain number for a range of Social Security numbers. They don't really want claimants to be calling. They pretty much want the attorneys to be calling or reps to be calling. But honestly, you don't get real far with it. I just think it's kind of a waste of time. You'll be on hold for an hour. Look, I had a situation. I got a case right now I'd won about 2 years ago, and the judge basically said that my client needed a representative payee. He didn't want a representative payee. And so it's been in limbo. And so they called my office and said, we want to talk to you about it, yesterday at 2:00. So 2:00 rolls around, I'm waiting, no call. So, they're just overworked, understaffed. It's a real mess. So I would tell you that if you don't see money in your account within 2 or 3 weeks, the best thing to do is to contact your U.S. Senator's office, say, here's a favorable decision. You've got the written decision. You can send it to them and say, look, I got my favorable decision. The money's supposed to be here. It's not. Can you make a phone call? And magically the money will appear. You don't want to overdo that. I mean, I wouldn't do it a week later, but 3 or 4 weeks, I think it's certainly appropriate to do that. Okay, Karen, one of my clients, has a couple of questions for me. All right, we'll say okay, and I already answered it in the chat, but I'll go ahead and answer it for everybody's purposes. Once you complete the function report and the work history report, do I send them to you for review before sending it to the Social Security office? Just dropped my water, but fortunately it was closed, which I've been known to not have it closed. So anyway, answer is usually I like to see those before we submit them. We can submit them electronically. Just because sometimes you'll put something on there, where again, it's too general. I can't stand very long. I can't walk very far, and I'll tell you to correct it. The other thing I really have been encouraging people to do is to do it in using the form online and to type it out. I realize not everybody's a touch typist and it can take long, but when you get these things that are handwritten, I look at these things every day, the function reports, the work history reports. And number one, sometimes it's very hard to read. And that's a problem because, judges are not going to spend a lot of time, or adjudicators for that matter, trying to decipher somebody's handwriting. That's number one. Number two is that Social Security is moving much more towards an OCR, optical character recognition, where they will scan it and have machines kind of summarize things for them. This is part of the AI that they're using now, and they're not using it a lot, but they're using it more and more. I use it all the time. And I will tell you that, when I do a query to Notebook LM, which is the one I use, the AI tool I use, if it's handwritten, it's not going to pick it up. It's real hard to pick that up. So you're really much better off, if at all possible, to type it out. So if you have the form, I don't know, I think she put some forms in here. I don't know, just the adult function report. Type it out. Just put it in, and let me look at it. That way you've got it and you can make changes easily. I like to look at them. I think, with the work function report, which is another form they give you where you describe what you did, not the work history, but the actual function, where you talk about how much you lifted, how long you walked. Those are really important because, in a vocational witness testimony, they're going to want to talk about what you did versus the way that job is normally performed. I was working on a brief today, and I had a client who was in sales, outside sales. He traveled and he sold, and he happened to sell carpeting and flooring, things that were fairly heavy. And, that job, as described in the DOT, the Dictionary of Occupational Titles, is a light, skilled occupation. I mean, it's not a highly skilled, but it's skilled because you got to know sales techniques and things like that. But it's considered light, which means lifting no more than 20 pounds. Well, he's lifting carpet and tile samples. And he said, in his report that he frequently lifted 25 pounds and occasionally, or not occasionally, meaning a third of the day, 50 pounds, and sometimes even as much as 100 pounds. Well, that makes a difference because he was denied at the initial stage because they said he could do light work. Well, his job is not a light job. And I'll tell you, at the hearing, the vocational witness will say this job was performed at medium or heavy. And by this, even the state agency conclusion about his ability to lift and carry, they're going to, they decided he was limited to light. Well, if we accept that and he did it at medium or heavy, he can't do past relevant work. Now we have a much better argument for the grid or functional capacity. So those are the sort of things I like to look at because, people sometimes just sort of, well, it was about 20 pounds. I'll talk to them and say, look, what were you lifting? How much was it? Was it 20 or 25 pounds? Was it 30 pounds? It can make a big difference. I mean, if you lifted 30 pounds occasionally, that sort of takes you out of light category. If you had a job that's normally sit down, but you were on your feet 4 hours, it takes you out of sedentary. And obviously most people aren't thinking about sedentary, light, medium, exertional levels because that's a Social Security concept. But I know it And, I want to look to see if, in fact, they were doing it at a much more, strenuous level than what the book says, because again, that can help us a lot in the hearing. So for those reasons, I like to look at it. Same with the function report. When you talk about, pain, or you talk about how much you can lift or carry, what should be consistent with your work history, but also should be realistic. And again, sometimes just asking the questions can get you to come up with an answer that's accurate and also can help you in your case. So yes, I do like to take a look at those. Not absolutely necessary. A lot of people don't send them to me, but if you want to, that's something I'm happy to do. I won't fill the forms out myself because I think it's coming from you, but I can give you some guidance. I've got videos about how to do it, kind of best practices. But the best thing to do would be let me take a 5-minute look at it, and I'll let you know what I think. And a lot of times I'll make a subtle change. It can make a difference in a hearing. Vince in Michigan, he is at 10 degrees above zero in clear skies. You can have that, buddy. 10 degrees, I don't think so. It was like I said, it was about 30, I think 28 to 30 most of the weekend. And actually, I'm as you probably all remember, I play tennis, and actually we had a match on Sunday. It was a mixed doubles. I'm in a mixed doubles season right now. And so under the rules that I play under, the Alta rules, which is the Atlanta long, they call it Atlanta lawn tennis. No, it's not lawn tennis, but like USTA, it's an association. The rule is if the temperature is 32 or below, or wind chill, is going to be really low, you can reschedule the matches. So I talked to the other captain. I'm like, you know what, it's 28 degrees. The wind chill is going to be like 10 degrees. Nobody wants to come out there in those kind of conditions. But I had one team, one of my teams, I had the female player grew up in Kansas, and the male player, he grew up in, I think, Delaware. So, to them, 28 degrees is like, middle of summer. So they played. In fact, the woman from Kansas, she's in a tank top. I mean, literally, it's 28 degrees. I got a jacket on with a heated jacket, ones with the battery powered, and I have like a sweatshirt underneath that, and I got a hat and gloves, and she's playing in a tank top. I mean, it was insane, but and they lost. So that's a whole different story. But some people can handle the cold, but not me. But you can have it, Vince. You can have it. Thank you for your time. For your review, says Jennifer, this will be my second review. I had to switch doctors. I'm wondering if that will affect. No, it will affect your case. No, I think if you switch doctors, the key thing is you're going to the doctor. So if they request medical records, assuming the new doctor is going to say treatment continues, your condition is not significantly improved, you remain limited in terms of your capacity to function, you should be just fine. And if you've made it through one review, the chances are you'll make it through the next one. All right, and Karen says definitely send for review. Absolutely, I'll be happy to do it. And then her question here is, how long are things taking in Oregon, and how do the judges? The judges, it just depends on the judge you get. I mean, every hearing office has good judges. Every hearing office has some not so good judges. I've never had a real problem with anybody in Oregon. They're not known for being unreasonable, and the time frames are pretty reasonable as well there. So I think we should be hopefully in pretty good case, pretty good space, pretty good situation. Her primary doctor does not fill out function reports. You have to go there. They may send you out for a consultative. And used to be, I was really a big proponent of these functional capacity forms, and I still like them if I can get them. It's not as necessary as maybe it once was. I think the medical reports can really talk about what you need to talk about, and your testimony would certainly talk about the functional issues. If you can get the doctor to fill out a functional form, that's gravy, but not every doctor will do it. And Social Security realizes that doctors don't like to work for free, and getting them to fill out these forms can be difficult. So it's not as big of a deal as it was. What I do is if I look at the record and say, you know what, I think we need something else, I might suggest that you go to a different doctor, not a Social Security doctor, but just a doctor for kind of a one-time evaluation. It's pretty rare that I would do that, but that does happen sometimes. Okay, this is another good question. nowhere near enough space on these forms to give adequate answers. Can you attach an explanation with the Word doc? Absolutely. And that's a great question, and you should absolutely do that. Absolutely do that. So, type it out if you can on the form. Go to type the form number in to Google, find the form, using a PDF writer or whatever, like Adobe Acrobat or there's a bunch of them out there, but Acrobat's the one everybody knows about. I use one called Foxit. All free. You can just type your answers out. I've even seen people they'll take the form, and because they can't get it to type on the computer, they'll just write in "see attached," and they'll type their answers out in a Word document, question 1, and they just type the answer out. That's okay too. As long as I just think if it's typed, it can be scanned, and that's where Social Security is going. Much more so than the handwritten stuff. I just think when you're writing by hand, it's just not ideal. Okay. All right. And Kevin says he's got some snow in Tennessee. Yeah, I know. We were supposed to get a couple of inches of snow. Nothing. And again, I don't want ice, but it would have been kind of fun to have a little snow, but nothing at all. Roy says, can I apply for SSDI while I'm living in Europe? I think you can apply, but they won't hold a hearing if you're not on U.S. soil. But I think you can apply, yes. Stephanie Alford, following to step 4, it was sent to my local office. Is that a good sign? It just means that they're working the file. So yes, that's a good sign. How can I get housing on SSDI? I don't really have an answer for that. That's sort of beyond what I do. I mean, to the extent that SSDI is kind of a guaranteed payment in the sense that it's coming from the government, the person offering housing should be comfortable that money is coming in. Now, the difference between, a person supporting themselves on SSDI and a person who's working, SSDI is, capped. I mean, you're going to get what you're going to get. Second thing is you can't garnish it. So, if somebody doesn't pay, they're a little more difficult to get out. You can still evict them if they're not paying, but, it is guaranteed. So that's a good thing. I just think you have to find a landlord who is okay with somebody on SSDI. And, I don't know that there's a real problem with that. I've not had people tell me there's a problem other than the fact there's not a lot of money. Okay. 83, the Casanova. Can your lawyer do all the talking for you during the hearing? Average hearing time. Average hearing time is about 45 minutes. And no, you have to answer the questions. So, the judge will ask you questions, your lawyer will ask you questions, and you have to answer them. And again, that's where good hearing prep can make a big difference, that you will be prepared, you'll know what's coming, and you'll have thought about your answers ahead of time. The time to think about a question is not when you're sitting at the hearing or, on your phone at the hearing. You want to think about those ahead of time, but you will have to answer them. Okay, so now we have a little controversy here. Elise, who is a friend of mine, who's an attorney, will be on next week, I believe. She says, and she worked for Social Security as a staff attorney, she says fully favorable decisions are easier to write. And Social Security gives the decision writer half the time to write them. So, all right, so she disagrees with Spencer. Spencer Bishens is another former Social Security attorney, advisor, and he claimed that it took longer to write the fully favorables. Elise is telling me opposite. So, Elise was there more recently, so I'm going to go with Elise. And since she's online here, we'll go with Elise, and we can talk about it a little bit next week on it when she's on live to answer your questions. And she will be giving her insight about what happens at Social Security, kind of on the inside, some of the things that, maybe we don't know on the outside here as attorneys or as claimants. All right, so I want to do something a little bit. I've got some more questions here, of course. I want to do something a little bit different. And what I'm going to do is I'm going to share my screen here where we are going to ask ChatGPT some questions. And let's just see how it does. And let me see if I can find, where's my ChatGPT here? Well, that does not seem to be it. I don't know. Now this is interesting. I'm not seeing it there. Well, here, let's try this. This will be it. There we go. Okay. Okay, so now you're seeing my ChatGPT. And so let's just type in, let me make this a little bit larger so you can see it. I thought this might be kind of interesting to see. How do I win my Social Security disability case early? Okay, let's see what ChatGPT tells us. Okay, here's a no-nonsense answer. Okay. So it says here, let me make this even bigger so you can see it all. There's no method that guarantees an early approval. That's correct. They do not ensure they don't promise fast outcomes. Correct. Early approvals are the exception. Also correct. Usually early means initial application or reconsideration. That is true. Almost always involves strong medical evidence, clear functional limitations, or minimal ambiguity for the examiner. I think that's right. When you apply for disability benefits, your case is reviewed by somebody called an adjudicator, who is kind of like an insurance claims adjuster. They don't have a lot of discretion. They're looking for clear evidence. And generally, they're looking for cases that are listing level, where you have a condition that is, you meet a listing. Go to meetalisting.com if you want to look at the listings. That's where Social Security has identified certain medical conditions that are on their face disabling. That's where you see a lot of early approvals at initial or recon. I also see some early approvals with the grid rules, because again, somebody over 55 who has, let's say, limited skills or no past work or limited past work and significant problems, both exertionally in terms of limiting their physical and non-exertionally, which would make it hard to focus and concentrate. Those cases can get approved early. Or occasionally you see them under a functional capacity theory where the evidence is just overwhelming. They're not listing level, but they've got 3 or 4 things going on where even the Social Security medical consultants realize they can't work. That's more the exception. But usually it's going to be people who are at listing level or at the grid level. They do not decide cases on how sick you are, well, or how many diagnoses or how long you've been treated. Okay, I mean, they don't decide. Those are factors. I mean, I think that the severity of your illness, I think, is relevant. I mean, realize you don't win in a diagnosis. That's true. But I think that, the type of diagnosis you have is relevant, because certain diagnoses are inherently, likely to be disabling. If you have recurrent DVTs, blood clots, pulmonary embolisms, blood clots in your legs, you don't win on that diagnosis, but there are functional limitations that are likely to arise from recurrent blood clots. And so I think that is relevant there. A person with congestive heart failure with breathing issues on nitroglycerin, yes, that is a medical problem. It's not maybe listing level, but it is relevant. So I would kind of disagree that, it doesn't matter how sick you are. It does matter how sick you are, because they look at medical conditions both at the adjudication level and at the judge level, and they look at it and say, well, is this condition one that is likely to produce functional limitations? Because I know when you get to a hearing, if you have a condition, let's say non-insulin dependent diabetes, that many people live with, either, and let's say you're taking a pill as opposed to insulin, and it's bothersome, and maybe you have some minor neuropathy or vision issues, that's generally not going to be disabling. Sleep apnea, probably not going to be disabling. So those are conditions that Social Security judges just generally feel like are, they may limit you to some degree, but they're not going to be disabling. So I think that the nature of the impairment is relevant, despite what ChatGPT says. How many diagnoses? Okay, I would agree. I mean, having 10 diagnoses does not make you sicker or more likely to get approved. I think it's the nature of those diagnoses. In fact, I'm almost of the belief that if you have three, or if you have a bunch of different diagnoses, focus on the 3 or 4 most serious ones. You can mention the other ones, and I would do it in a brief, but I think that the ones that are most symptomatic are the issue. I was working on a case today. My client has HIV, but it's under control with medication. There was one medication that did cause some complications, but he's not on that anymore. It does affect him mentally, okay, which is understandable. But I'm not going to make that the center point of my argument because it is not symptomatic, and it's not really a disabling condition at this point. There's a lot of other things that are much more serious. So, it's something. If you got 10 things, I'd put them in the brief. I'd focus at the hearing on the top 2 or 3. But so that's correct. It does not depend on my diagnoses. How long you've been treated, again, I don't agree with this. I think that what they call longitudinal treatment is relevant. If you have a condition that has gotten worse over time, that is, I think, very, very relevant. And Social Security will look at the longitudinal treatment record. So, yeah, I think that is very relevant. They are going to look at objective evidence. That is true. MRI, CT, X-ray to some degree, abnormal labs, yes, clinical findings, objective evidence, not just, claimant said. So, yeah, they're going to look at these type of things. Subjective claims, complaints, there are rulings out there that say that fibromyalgia, for example, which is purely subjective, judges have to give it weight. Now, some will, some won't, but subjective. I would just say this. I would say that whatever your objective issues are, I think that the subjective complaints need to be consistent with that. You have a bulging disc. It's not logical for the most of the time that you're going to have numbness and you can't feel your left leg. It's just, unless there's some real nerve compression there. It's just not consistent. So the subjective complaints need to be consistent with the objective findings. So, and there's other things here, but you can sort of see, I think that the big picture here is, and maybe we'll come back to this after taking some more comments here. Pardon me. I think that you're getting some general information. It's not wrong, but it's not exactly right. And, I would be careful about relying just on this. So let's go back to our questions. Maybe we'll come back to this later, but I think it's instructive to see, because I think a lot of people are now turning towards ChatGPT, and it's a viable source of information, and there's good information on there. You have to be careful, because a lot of times it'll tell you what it thinks you want to hear. If you say, I've got a really bad back, how do I win Social Security? And it'll kind of give you information that it basically tells you what you want to hear. So when you prompt it, and this is a whole different ball game, but when you prompt an AI tool, you need to basically say, don't blow smoke up my what, give me the truth, and don't tell me what I want to hear, because it's known for doing that. And ChatGPT in particular has a problem with what are called hallucinations, where it will make stuff up that sounds really good, but it's not accurate. So you got to really be careful, about that. I mean, if it references, for example, a Social Security ruling, which is sort of a form of precedent in the Social Security world, you want to check that ruling to make sure that has not been overruled, because there are rulings that are no longer in force, and it may not know that. I've seen that happen several times. So you got to be real careful about that. So, all right, let's go back to some of our questions here. Let's see. Okay. Hello, Jonathan. Hello. How are you doing? Jimmy's first time here. Well, welcome, Jimmy Brunson. I'm glad to see you. Thank you for joining us. PMFG 875, concerning expedited reinstatement. Should a person on SSDI refile if they've been told the local office only takes appointments? They're sent a text about appointments aren't available. I guess I'm a little unclear, because if you're expedited reinstatement, that means that you have been knocked off because you went back to work, and now you're in that 30-month period, I think is what it is, where you're asking them to reinstate. My understanding is that you ask them to reinstate, and they do, and then they look at it. I don't deal with this, honestly, very much, so I'm probably not the right person to ask about it. But I don't like when you say refile. The problem is when you start a new application, now you got an existing case going on and you got a new application. It's going to be a mess. I think that this might be a situation where, you try to get a hold of somebody live if you can, or reach out to your senator and say, I need some guidance as to how to do this. Um, Again, if you look at what they say on Social Security says on their website about expedited reinstatement, it says contact your office and tell them that you stopped work and you need to be reinstated. A little too general for me. So, I would say try to get somebody you can talk to or do it in writing, and you may need to reach out to your senator. And definitely, if you write to them, do it return receipt requested so that they got it. But it's a little bit of an unknown to me because I just don't deal with this. I really don't want to mislead you. Good evening. My hearing is in April in Illinois, getting nervous, 60-year-old with triple spinal fusion, always in pain. I would say this. I'm not going to give you an answer based on what you just told me here, but I will tell you that when I see a person, when somebody contacts my office, they're 60 years old, they've had multiple, 3-level fusion, and they're in pain, which is not inconsistent with a 3-level fusion. That sounds like a pretty good argument there. I mean, that's a case that I would take a really long look at because I think it's probably a winning case. Now, you could get the judge from, that doesn't approve anybody, and I would definitely look up the judge. But generally speaking, if you're over 55 and you got something objective and serious like that, you're in pretty good shape. Those cases, the presumption, in my opinion, would be you're going to win. But it's a fact, obviously fact dependent, but I think you're probably in pretty good shape, and certainly talk to your lawyer about the questions we're likely to get and who the judge is. But I would tell you overall, I would feel probably pretty comfortable based on what you've said to me there. ABCD, can I get disability for double vision? It kind of depends. I mean, look at the listing for, I think it's, I want to say listing 2. Let me see if I can tell you. The listings for vision is special senses listing 2. So if you look at listing 2 and you look at 202, 203, 204, loss of visual efficiency, I think that not being able to, if your double vision is constant, there's not a lot of jobs you're going to be able to do because you're not going to be able to see, and you're probably going to have headaches and you're going to be dizzy and so forth. My experience with double vision is that A, in some cases it can be corrected with glasses. B, that the brain will many times figure out how to resolve it, or they put a patch over one eye. It's rare that you see a person with double vision where it's a permanent condition. It could happen, but it's a little rare. So, an ophthalmologist would be helpful to have an ophthalmologist give you an opinion about the nature of it, what the cause of it is. Is it something that is permanent? Is it going to last at least a year? And do you meet a listing? This is one of those cases where I think that if you have a functional form or a statement from your doctor, that would be helpful. The reason the light went out was I'm using a green screen, which is why this looks a little clearer than it did last week. And I realized right before I went on that when you have a green screen, you got to light it up from both sides. So I've got my normal video light over here to my, I guess it's to my left over here. But the one on my right was battery powered and the battery just ran out. So next week I'll have the one that is plugged in over there. So it won't run out. So anyway, that's why the lighting is looking a little less strong here. Okay, Dimple Bellamy, how are you doing? You got it, Dimple. Nice and that's a great. Anybody know anybody else named Dimple? What a great name. So Dimple, thank you for tuning in every week. I really appreciate it. Good to see you here. William Hicks, 51 years old, motorcycle accident at 18, filed for SSDI. They removed your latissimus muscle from the back to repair your legs, reasonable to claim chronic back pain with a missing major muscle. It's not unreasonable. I think that, if they remove a muscle in your back that is part of the stabilizing muscle, and you have medical support that it is, consistent with a level of pain, yeah, I don't think that's unreasonable. Again, having a doctor talk about the effect of removing this muscle and the effect it's going to have on you, I think that would certainly be helpful, because, just because they removed that muscle doesn't inherently mean you're going to have severe pain. You want the doctor to say that you, William in particular, is having pain because of X. He's carrying too much weight, or he has, decompensated because of his leg, whatever the case may be. You want to try to put as much support behind that, but don't assume it's reasonable, but don't assume a judge will connect the dots. That's what you want the doctors to do, is to connect the dots for you. And again, your subjective complaints are relevant. So, what I would do is I would go to, let's say, WebMD or the Mayo Clinic and say, what are the implications, or even a ChatGPT for that matter, what are the implications of a removal of the latissimus muscle to repair a leg? What is the implication in terms of back pain, recovery time, things like that? And so get a sense as to what the medical literature says, and it will, I'm sure, say that some people are going to have a longer recovery than others, and you just want to document the issues you're having. Realize you've got to have a condition that has lasted or expected to last 12 consecutive months. The question in my mind would be, with physical therapy and exercise, would your condition improve to the point where you could go back to work, or is this a permanent problem? Hackasad, who's here every week, regarding decision writers, what do they actually do once an ALJ approves a claim? And Elise will talk to us about this next week. But my understanding is the judge will, send electronically his or her notes to a decision writer. And these are attorneys that work in an office that could be, halfway across the country. And there's a template they use, the same template we see in all the decisions, and they will draft a decision and, reach the conclusion the judge wanted to reach. They use something called a 5-step sequential evaluation framework, which is what I do in my briefs, by the way. And the framework would be: step 1, are you working? So the judge will find you're not working. Step 2 is, do you have a severe problem? And severe basically means, is it diagnosed? Is it something that is going to impact you work-wise? Number 3 is, do you meet a listing? And the judge will say yay or nay. Usually in my briefs, I'm going to say we don't meet a listing, because at a hearing, it's pretty rare. Number 4 would be, can you return to your past relevant work? And either A, because the past relevant work was much more physical or much more cognitively demanding than what your capacity would be, we get rid of that. And then the burden of proof changes to Social Security. Can you do anything else? That's step 5. And the evidence needs to show that you would be, generally it boils down to, you would be unreliable. You'd be off task, is the term they use, or you would be likely to miss more than a couple of days of work per month. And the judge will conclude that you are, in fact, disabled. And usually what they'll do is they'll come to the conclusion that your functional capacity is less than what would be required by a minimally demanding job. I mean, I call it a warm body job. Then they'll say, even if the person has some capacity, the grid rules would result in this person being disabled, grid 201.06 or 202.06, something like that. So that will all be, I assume, in the judge's notes. The decision writer, I think, has some latitude to make certain assumptions, and that they will send it back to the judge for review. And if the judge agrees with what's written, it'll be released. Now, I will tell you, and again, Elise will tell us more about this next week, when I get an unfavorable decision and we appeal it, there may be mistakes in that decision. And the mistakes could be in the part of the judge, or it could be in the part of the decision writer. I was looking at one not too long ago where the judge found this is going to sound really picayune, but I'm going to tell you what it was. The judge found that the person's ability to use fine motor manipulations was occasional. Okay, occasional meaning 1/3 of the day. In the hypothetical that the judge gave to the vocational witness, the judge said frequent. Well, the finding was occasional, but the hypothetical said frequent. Frequent means 2/3 of the day. If you didn't look for it, you wouldn't have caught it. I mean, it's really kind of picayune, but that was enough to get us an appeal and a remand back to the judge. And what happens at the next step? The judge could ask a hypothetical or make a finding that handling and fingering is frequent, and then the hypothetical fits. But who knows? I'm just saying is that's the sort of thing that could be a problem that the decision writer made a mistake, or the decision writer. I've seen situations where they just the hypothetical. And this is usually more than the judge. The hypothetical does not include all the limitations that were brought out in evidence, and sometimes, and again, Elise can probably tell us better. It may be that the judge included it in the hypothetical, but it didn't get into the decision. That could be a problem. So there's just any number of ways to go after a decision. I think in some cases, the decision writer may be to blame. I think a lot of times it's the judge was a little sloppy in their reasoning. And again, there are judges that I deal with on a fairly regular basis who, they issue an unfavorable, I appeal it every single time, and 90% of the time I'm going to win because they're just really sloppy. So, but yeah, that's what they do. But that would be something that a person who did that is going to be better to answer, and we'll find out from that resource next week. Hey, Christy, you got to 24 degrees at night. Now that's pretty crazy. In Jacksonville, Florida, 24 degrees, and we were a little colder than that. But yeah, there was, I think I saw someplace on the news where like iguanas were falling from the trees and crazy stuff like that. So in Florida, it doesn't normally get that cold, but we had that polar vortex coming through. Elise is in New York, and she sent me a picture of like snow up to the second floor window of her house, which is a little too cold for me, but it is what it is. Okay. Gospel. I'll just call you Gospel. I applied for disability October 2025. I'm 65 years old, denied 2 days ago. 66, is it wise to apply for recon? Is this a case we'll consider? I mean, I think the question is, have you already claimed retirement benefits? If you're getting full retirement benefits, which you might get at 65 or 66 or pretty close to it, the difference between disability and retirement is going to be so small that it probably would not be something I'd be interested in. In other words, if somebody takes early retirement at 62, they're usually getting 70% of their full benefit. Retirement, full retirement, and disability are about the same. So let's say, just pick a number. Let's say your full retirement and your disability is $2,000 a month. Your early is $1,400. I'm just picking a number. There's a $600 difference. Well, if it takes 2 years, 600 times 24, yes, that would make it worth my while. If it's, you claimed early retirement at 64, now you're 66, the difference is $100 a month. $100 a month times 24 months, let's say it's going to take, or even 12 months, because an older person is likely to get approved early. You may be looking at $1,200, $2,000, not going to be worth my while for the most part. So it's going to really depend on when you took early retirement, if you did, and the difference between full retirement and your disability benefit, your early retirement and your disability benefit. And that would be what I'd make a decision. So, the question I would ask you is, how much are you getting now? When did you take it? At what age did you take it? And if you know, what is your full retirement amount? Okay. Bryn, my client, have you heard anything about my onset date change? I think you submitted it. Hearings in March. Yes. I have not heard. I did submit it. I know we have a hearing coming up. I'm just finishing up my February hearing preps. I was working the last one today, and as soon as I like to get my briefs filed ahead of time. I've got almost all of them filed. Once I finish the last one, I'm going to start hitting March. I think yours is in later towards March, but I will definitely make sure we get that brief in early, and that we reemphasize that we change the onset date, because in your case, if I remember correctly, the original onset day was after your date last insured, which means there's no benefit. So we changed it to before then. So I did it in writing, but we'll make sure it's done again. But yeah, I'm going to be starting to work on my March cases this week. Can I answer your email? Still waiting. Yes, I got your email. And there's some extenuating circumstances. I needed to write you back. I will write you back tomorrow to explain what those circumstances were, and I will get back to you. Yes. And I hope family is okay. I'll just leave it at that, because I know crazy things are going on in the world. Hello, Cynthia. How are you doing? Good to see you. Another one of my clients. Karen, my pleasure. Thank you very much for tuning in. Roy, I think you've already answered that. I think you can, but you got to be in the States at a hearing. What's okay? 1947 GMC. Do you have a 1947 GMC vehicle? That's interesting. Okay, I'm guessing that's what that means. I wonder what's really up. I don't know how AI is going to kill the economy, and AI doesn't pay taxes, will mess everything up in the U.S. I'm not quite there yet. I know there's a lot of people who are very, very concerned about the effect of AI. And again, I don't want to get off on a tangent here. I use AI a lot, more and more. It's a very powerful tool when it's used correctly. My own observation is that, AI is still, first of all, we have not had the shakeout of all the AI companies. You've got all these different AI tools. This reminds me of the .com, the bubble, where you have a million companies, a million different, technologies, and the survivors have not been determined yet. So I think we're early on in that. I think number two is AI is literally changing every week, and there's new stuff that's coming out. We have not had any real regulation. I think that's going to come out. I think that learning how to use it will become a skill that you have to really, learn. I think, again, it's going to happen quickly, but I think we're probably good 4 or 5 years from that. I think there's still going to be a human element, because AI can do a lot of things, but it doesn't have certain judgment. It will get smarter and smarter. And, there's some podcasts I listen to where people are saying in 20 years, it will do, anything a human can do better. Some people say in 5 years, it'll equal what a human can do. A lot of it has to do with how you prompt it. And again, it's my own experience. I'm pretty comfortable with technology. And when I do a prompt for my, let's say do a pre-hearing brief or a medical summary, I'm now on version 8 of my prompt, 8. So, and it's still not 100%. It's still good. It's getting a lot better. But, there's always things that I got to check. And, I haven't, for example, figured out how to get it to identify the exhibit numbers in the file. So when I get a file, that it's a PDF file, and Social Security numbers it on every page on the top corner, it's got, 1F page 4, 1F page 7, whatever it may be. And it's typed. It's something that can be scanned. AI cannot read that at this point. Now, they're going to get to the point where they can, but right now it can't. So we're a good ways away. And I think the second point would be that whatever jobs are lost by AI, which are going to be a lot more, routine data entry, things like that, there will be new jobs created. Now, these new jobs are going to require more education, more skill. In fact, Elise and I were talking about this the other day. I wouldn't really want to be a lawyer who's 30 years old right now, because everything that you would have learned is going to be changing. And, you're going to have to really adapt. I've got my tennis coach, his daughter is in law school, and and I was talking to her, and she was home for winter break. I said, learn, how AI can really affect the practice of law, because it's going to be a big part of it. And a lot of the kind of, just, mentally, boring, just, functionary kind of things that lawyers have been doing are going to disappear. I think that we're going to see more and more, like, a simple will. AI can do that. A name change, a simple divorce, AI can do that. But there's certain things that it can't do at this point. Now, in the Social Security world, my prediction is that AI will be able to identify with a fairly high level of confidence the types of cases that are deserving of approval. Social Security has, probably millions of decisions and millions of profiles out there based on age, the type of impairment, MRIs, things like that. And let's say you take out the 10 or 15% of judges that have, really low or really high approval rates. And so you're working with the ones in the middle. You could create an algorithm. You could query an AI tool with all that data in there and ask it to come up with a way to profile and predict what a judge might do with certain fact patterns, and it'll be right most of the time. I'm doing that in my brain right now. Okay, I look at a file, I can tell because I've done this 35 years. I kind of know, and I've even what I'm doing now is I'm putting into Notebook LM, which is a closed system, by the way. It's not, doesn't go outside of what you tell it, and I put in articles I've written. I put in articles other people have written. It's like a knowledge base, and so my staff can query that knowledge base. There's actually some other technology which is really wild, where you can actually, you train it and it shows a video of you, and you can query the video. You could query the avatar for Jonathan to ask me questions. I haven't done that yet, but maybe at some point we'll do that. I need a haircut before I do that, because right now my hair, I need to go to the hair person because it's been really busy, but different story. But anyway, but yeah, there are a lot of things coming down the pike, but for every new technology, there's new opportunity. When I remember when the internet came along and became a viable tool in the 90s, and everybody thought, okay, this is going to eliminate this, that. Well, it becomes a tool we all use, and it creates its own set of problems. So there's going to be a shakeout. There's going to be some changes, but I don't think it's going to kill the economy. And you can bet your bottom dollar that the politicians will figure out a way to tax some of this stuff. So we won't have a problem with that. I don't think. So I think we're probably 10 to 15 years away from it being, a real issue. And B, I don't think it's just going to create new opportunity and maybe just make some of the jobs that are more rote and routine, things that machines do, just like any technology has done. When cars came along, it got rid, it didn't eliminate transportation, it just went from horses to cars. When airplanes came along, you went from trains to airplanes. We still have trains, but now we have airplanes. So it's just different. It's going to be different. It's going to be interesting. I think that the next, 20, 30 years will be really, really interesting. We live in very, very interesting times. And, I don't think that we're going to reach a point where people don't have to work because everything's being done. It's just you're going to be doing different things. But, and this is the last I'll say about it, if you have a school-age child, or if you're in school yourself, you got to be, your mindset needs to be, I've got to constantly learn. You can't just say, like, I went to school, I know what I know, and I'm going to do this. You're a truck driver. Well, there's going to be automated vehicles that are going to eliminate some truck driving jobs. So it's going to be a little bit uncomfortable. If you're used to watching TV for 4 or 5 hours a night, get out of that habit. Learn. Go to YouTube and learn something, because you can't rely on things being the same. The rate of change is very, very quick, and if you can adapt to it, you'll be ahead of the game. If you don't adapt to it, you're going to be left behind. And like I said, I'm finding that when I'm doing my hearing prep, I'm using AI for brief writing, for hearing prep, for medical analysis. It has cut my prep time, dramatically. I can be a lot more efficient. I can do other things. So I think that's what I would tell you. Just be in a learning mode. Cynthia says, does GERD with esophagitis and metabolic acidosis have any relevance for SSDI? Yeah. And you're talking about a lot of discomfort whether when you're eating or drinking or just, anytime during the day, anytime you have pain, discomfort with something like swallowing, breathing, it's going to interfere with attention, concentration, focus, which means that certain skilled and semi-skilled jobs are going to be really hard to do. Imagine, trying to do a job where you're really focused on, let's say you're a pharmacy tech and you've got to make sure that you put the right pills in the right bottles, or that you are compounding medicines, and you can't make a mistake. You can't put 1 milligram when it's supposed to be 0.1 milligram. Well, imagine you've got your chest is on fire from just this GERD, this terrible pain, and that every swallow, every breath you take you're in terrible pain, or you've got migraine headaches and you just can't focus. Well, you can't do a job where you've got to be really on your game. So that's going to maybe remove a lot of skilled and unskilled jobs, and make skilled and semi-skilled jobs, and limit you to unskilled jobs. Well, now we may have a grid rule argument. Now there are a lot fewer jobs out there that you could do. And if your pain level, discomfort level is to the point where you're having to take unscheduled breaks, or you've got to take medicine that is sedating, or you are in such discomfort that you can't do anything other than just lie down and put yourself in a prone position where maybe you have less fluid going into your throat or whatever, you're not going to be able to work. So at a minimum, I think it's going to make it more difficult to do skilled or semi-skilled work. But if it's to a certain level, it could eliminate everything, or that in combination with something else like severe migraines or severe back pain. When you add them together, it's going to make it really, really hard to focus and concentrate, and maybe hit that threshold where you're off task 15% of the workday, or you are missing 2 or 3 days of work per month. That's the sort of thing that I think, even something like GERD, which is fairly common, it can rise to that level. Hello, 904 Reselling the South. Hope you're doing well. Hakasad, does the health issues negatives on DDE provide a clue as to what the ALJ would focus on? Okay, I think what you're asking me is if the state agency, the people that made the decision, initial and recon, is that going to give you any idea what the judge is going to focus on? The short answer is no. A judge will tell you at the beginning of the hearing, I am not bound by any decision made at any other level, at the state agency level. So I'm not bound by that. They do look at it, and many times the first hypothetical question will be what the state agency found. When I do my briefs, I will use the state agency findings to the extent they can help me. And I'll give you a couple of examples. I've seen many cases denied on the grounds that the person could return to past relevant work. Well, under the Social Security rules, the look back, assuming your date last insured in the future, the look back for past work is 5 years from the date of your hearing. So if we're in 2026, if you last worked in 2020, there is no past relevant work. Well, if you applied in 21 or 22, the state agency may have looked at your past work and said they could do your past work. It was relevant at that point. It's not relevant now. So I'm going to make note of that the state agency, reached a conclusion that it's no longer valid because the person doesn't have any past relevant work. It's more than 5 years since from the time of the current time of the date of the hearing. That's one thing. Second thing would be if the state agency finds that you could do a limited range of light work. What's limited? Well, let's say that you cannot reach overhead with your right upper extremity. Well, I may disagree with their conclusion, but I'm going to use, hey, they said you could not reach overhead with the right upper extremity. I'll put that in my brief. This is something they've already found. Let's put the judge on notice. They've already made a decision. You're not bound by it, but it's harder for a judge to say, well, 2 levels, they've decided you can't use the right upper extremity. I'm going to find that there is, he could use, there's no problem with the right upper extremity. A judge is not bound by it, but everything that works in your favor early on, put it in at the hearing level. So they're not bound by it, but you can use things that work in your favor. I've had cases, I've had a couple this month where the state agency reached some conclusions, and again, the past relevant work issue, and now there's no past relevant work. Well, person's 55, limited to light work, light RFC, light exertional capacity. They were denied because they could do past work. Now there's no past work. By definition, they are disabled. And the judge said, well, state agency found that you're limited to light work. That's consistent with the evidence. No past relevant work. I guess you get approved. And literally the judge even said it that way. I guess we're going to approve you. So yeah, I look at what the state agency did and use those things that can be beneficial to me. I will look at the DOT codes they come up with for past work. Not always accurate, but it gives me an idea of what they're going to come up with. I want to know why they denied the case. Look, I had one, I'll give you another kind of a crazy example. I had a case, I was talking to my client today. He was approved he's going to be 55 in April, okay? He was approved as of December of 2025. Like, why December of 25? Well, the reason was that they found that even that he turns 55 in April, and there's a rule, a Social Security guideline that says a person within 6 or 7 months of the next birthday, they can use that next birthday to find the grid rules apply. Well, the issue is they moved his onset date from 2021 to 2025. They cut him out of $100,000 of past due benefits. I called him up and I said, look, they approved you, and you don't want to look a gift horse in the mouth, but which is a strange expression. I don't know, I never really understand that, but okay. You don't want to not give credit or give some weight to the fact that you were approved. But if we appeal it, what is the worst that's likely to happen? You're going to get approved as of age 55 because you had multiple back surgeries. You're not going to be found that you could do medium work. And, probably by the time of the hearing, there'll be no past relevant work. You'll grid out. So, worst comes to worst, you're going to end up in the same place. If we win and show you're limited to sedentary work, then, you get $100,000 in your pocket and you get Medicare, 2 years ago, as opposed to waiting 2 years for Medicare and no past due benefits. Let's give it a shot. The cost benefit analysis makes sense. So I had to look to see what they did. I understand what they did. And I know going in that, a judge might do the same thing, but, it's worth a risk. To me, it's worth the risk because the odds of a judge denying the case are very, very low. The odds that the judge could approve it are, maybe 50-50. So why not give it a shot for $100,000? So yeah, I always look at it. I think it does give you some idea that, judges are going to look at that, but they're not bound by it. But my point is, if the DDS draws a conclusion and it's wrong, I want to address in my brief why I thought that was wrong, to take it off the table if I possibly can. Robert Hayden says, I don't know say much there, but okay. Maddie is one of my call screeners. Good to see you. Really good. Madeline is excellent. If you ever dealt with her, she knows what is what. And good to see you. Good evening. Kevin says the grid rule works for anybody at 60. I'm 60. Yeah, the grid rules, the breakdown for the grid rules is there's one very limited exception. I'm not going to worry about it for below 50, but it's pretty rare. I've had it happen once in 35 years. Most of the time, it's going to be age 50 to 54 and 364 days. If you're limited to sedentary work, you can grid out. At 55, even if you could do light work, you can meet the grids. And I win a lot of cases on grid rule 202.06. Go to gridrules.net if you don't know what I'm talking about. And 202.06 basically says that you're limited to light work, no transferable skills, and you have a semi-skilled, past work and a high school education or more. If I can prove by pain, medication side effects, non-exertional impairments that the person is limited to light work, which again, light work is lifting 20 pounds frequently. That's a lot of weight. I win a lot of cases with light work. And so, yeah, that's a really good one. At 60, the big advantage at 60 is there's not really another grid, but there is a POMS regulation, and that stands for Program Operations Manual, that says when you're looking at transferable skills, and again, look at the grid rule. It talks about transferable skills, meaning things you've acquired. Let's say you did sales skills, customer service, things like that. At age 55, if you're limited to sedentary work, the POMS regulation, particular one, says that there is a standard for evaluating transferable skills that you have to show that there would be a minimal vocational adjustment. And basically what that means is that, you would have to basically be in the same industry doing almost the same job. Well, you couldn't do that job. So that's a really helpful element there, that the minimal vocational adjustment standard to transferability of skills analysis, because it basically says you've got to be able to go back to what you were doing. At age 60, this minimal vocational adjustment standard for determining, transferability of skills applies if you could do light work. So imagine you're 61 years old, you have past work doing whatever, sales, marketing, truck driving, whatever the case may be. You're limited to light work, which again is a fairly, I wouldn't say easy, but it's not that difficult to do. And you've got some skills, but they were in the carpet industry, they were in the medical field, they were in, I don't know, they were in the accounting field, secretarial work. Well, minimal vocational adjustment says that Social Security has to identify a job essentially in that vertical, in that field, that you could do without without learning anything new, is really what it means. Well, that's hard to do, because when you're 60 years old, you heard me talking about the importance of learning new stuff. When you're 60 years old, you're probably not going to go back to school. A lot of people in their 60s, maybe less so now than if you ask me this question 10 or 15 years ago, people in their 60s aren't usually in a mode of learning new stuff. They should be, but they're not. And it's hard, especially if you never really did computer work. I know a lot of people in their 50s and 60s who use a computer for what they use it for. They maybe can use a computerized cash register. They can write a letter in Word, but they're not going to be able to, go into ChatGPT. They're not going to be able to create a PDF document and combine it together. They're not going to be able to cut and paste things that are, not too hard to do, but they require a certain level of skill. Well, you're going to ask a person who's done construction work or truck driving, you're not going to say, go into an office environment where you're going to have to learn things about computer work that you never learned. And again, I'm pretty good on the computer. I'm a computer person. I like it. I mean, I always learned it. I was always the first one to do it. Windows 11 comes along, different interface. Well, I was able to figure it out, but there are people in my office who have a real problem with it because it looks different. My wife, for example, is very, very smart, very, very good lawyer. But when I get her a new computer, she wants it to look exactly the same. Hard to do. But, she doesn't want to have to learn a whole new interface. I mean, just to give you an idea, we use in my office, we use a program for word processing called WordPerfect, which at one point, 30 years ago was the go-to for lawyers. Of course, now everybody uses Word, and I've got Word and I can use Word fine. My wife can't use Word. She's never used it before. So we've stuck with WordPerfect. Aside WordPerfect, it's actually a pretty good program, and I like it, and I think it does a lot of things really, really well, probably better than Word in many respects. But 99% of the world uses Word, so I use Word, and interact with people using Word all the time. It's not that hard, but again, I understand the flow of it. But if you gave my wife Word and said write a document, she would be completely lost. It just doesn't resonate with her. Not a cut on her. It's just that's not important to her. She's focused on winning workers' compensation cases, which she happens to be very good at. But there are a lot of people who don't know programs. They don't know Word. They don't know Excel. They don't know, even going online to do a web-based program, some sort of a customer, what do they call them? Customer service program. I'm drawing a blank on the term, but where you're interacting with customers, you're keeping track of what your customers are doing. People don't know how to do that, and if you're just not in that mode of thought, can be very hard to transfer those skills. So bottom line is at 60, it's going to be even easier to prove that there's got to be more than a minimal adjustment to a new type of job. So that's why age 60 and 61, is a sweet spot for winning disability cases. I think 55 is really good, gives you a lot of options, but 60 is even better. And so that's why that gentleman who said, I'm 60 years old, I got a hearing coming up, 3 herniated discs or 3 fusion surgeries, something, or I think a 3-level fusion, you're 60, you're 58, 59, 60. That's why you have a really good shot at it, because the grids are going to really work in your favor. Okay, 83, the Casanova, DVT and cervical radiculopathy. Again, you don't win in a diagnosis, but DVTs are a problem. Those are blood clots, typically in your legs, although it could be in your lungs, which is what they call a pulmonary embolism. But a DVT is really serious because you throw a clot, it goes to your lungs, your brain, you have a stroke, you have a heart attack. And doctors are very, very concerned about that. So what they do is they put you on anticoagulants. And they may want you to to keep your legs extended. Well, you can't work if your legs have to be extended during the day. So, and anticoagulants are a problem because that means that any kind of work hazard, you can't be around. You can't be around moving machinery, unprotected heights, things like that. So it's going to eliminate a lot of jobs. And the biggest thing is you cannot be in you can't be seated all the time, because if you've got DVTs, you can't have your legs on the ground all the time. You got to extend them. So if you have medical evidence that you've got to have your legs extended at waist level or heart level for 20 minutes an hour, well, that's an unscheduled break. That's an accommodation that is inconsistent with competitive work, and you win if that's what the evidence shows. Cervical radiculopathy, which means pain in the neck that radiates into your arms, going to make it really hard to type, going to make it hard to lift. Again, there's levels of cervical radiculopathy. It could be mild, or it could be your hands are totally numb. But yes, that's going to be a factor. The degree of it, what the MRI shows, is going to really tell me more. But, I think the combined effect of those things are going to create some work impediments. How severe, how significant, I can't tell you. But they are going to be, I think, significant enough where it's going to improve your chances at winning. If you're over 50, your chances are even better. If you're 35, it can be more of an uphill battle, but not impossible. But I think it's going to be a little more difficult. Robert, on SSI, turned 67, having issues with OIG. Can I pay you to advise me? Good reason to believe I can't trust email or phone. Possible go to your office and talk to your staff speakerphone. Robert, that's probably not an issue that I deal with enough to offer guidance, but why don't you email me? You can ssdanswers123@gmail, and I will get you in the hands of somebody who can help you with that. Because, like I said, I don't really deal with, I'm not sure what exactly the issue is, but you're having OIG, Office of Inspector General issues. That's a little bit beyond what I do, but I can put you in some good hands there. So just email me and I'll get back to you on that, okay? Okay, well, we've already discussed that. Cynthia says, congratulations to Kevin, very much. Okay, when one gets approved, asks Her Majesty, if you're a queen, then you probably don't need to be on disability, but okay, I'm assuming you're not really Her Majesty. That's a screen name. When one gets approved for SSDI, and the letter says your case will be reviewed in 5 to 7 years, they're referring to when you got the approval letter or the date you're found to be disabled. I believe it's the date you got your approval letter. So if you got your approval letter March, or let's say February 3rd, 2026, then the 5 years would be from that date, not from your onset date. That is my understanding. And again, maybe Elise can tell me differently, but that's my thought. And Elise says, this is going back to my comment about the decision writer. She says, blame the judge, not the decision writer. Look, when I'm appealing something, I'm going to blame whoever I got to blame. It's not about blame, it's about the mistakes. But yeah, look, I'm sure Elise made no mistakes in her entire career with Social Security. So does not apply to her. But there may be some decision writers that weren't quite as diligent and may have made a few mistakes. But I would agree, at the end of the day, the judge, it's going out in the judge's name. The buck stops with the judge. But I'd be willing to bet that there are occasions when the decision writer was a little bit sloppy or, not fully trained, and that could have been the mistake of the decision writer. More experienced ones know the mistakes not to make, but newer ones, I'm sure there are probably mistakes that are made. But I would agree in principle, being facetious here, but I would agree that the judge is ultimately the buck stops with the judge. Christina, one of my regulars, hello from California. Hello, Christina. Hope you're doing well. Candy Levy, is it possible to win a disability case? I assume Social Security means disability without a lawyer. It is. Absolutely. In fact, that's kind of the reason I've got all these videos out there. I'd actually written a book about this, which is we'll call it out of print right now because I don't have any more copies of it. I've got the CD, but not the hard copy. I've been trying to revise it, just hadn't had time to. Certainly, an initial or recon, if you meet a listing and look, I'll tell you, go to ChatGPT, go to these, go to an AI tool, and follow some of those things, get the forms in correctly. If you have a really, really serious problem, your listing level, your compassionate allowance, and you tell them that, yeah, you can win. If you're diligent about getting the forms back, yeah, I would not go to a hearing without a lawyer. I think that, it's easy to make mistakes at the earlier stage. Again, something as simple as doing your forms handwritten as opposed to, typing them in, something as simple as not focusing on your functional limitations. There's value to having a lawyer help you with that, but you can educate yourself. And I realize if you get approved in initial, your lawyer may get paid very small amount of money because it's maybe not much past due benefits, maybe 5 or 6 months. So you may end up paying a lawyer $500 or $600. To me, it's well worth it, but it's not absolutely necessary. So following, people who have filed an initial application or they filed a recon, I'll say to them, wait till you get your decision. If you get approved, you don't need me, and that's fine. Look at my YouTube, do your own research, go for it. I mean, it does not offend me in any way, shape, or form because money's money. If you can do it yourself, you can. So yes, it is possible. The system, and I'll go back to what Spencer said in his book, and he's got a book talks about this. And you can look him up, Bishins. Spencer Bishins has a book on Amazon you can get. He thinks, and we'll see what Elise thinks next week, Spencer thinks the system is designed to make it really hard for you to win because they want to keep the money in their account as opposed to paying you. They got a trust fund to preserve. He thinks that is behind the reason, that's the reason why so many cases are so difficult, but to get approved. But yes, you can. You can win without a lawyer. Not necessary, but I think it helps. 4 o'clock lover. I'm not going to even ask where that comes from, but I agree that it was crazy to be 24 degrees on Friday and Saturday. There are a few snow flurries and it didn't last long 5 years ago. Florida's not used to that, to 22 degrees. Yes, that is correct. I went to school in New Orleans at Tulane, and I think New Orleans gets snow like once every 10 years. And I was never there for it because it was always over winter break. But I think a couple of times we had flurries. But yeah, some of these places, they're not used to it. You have this polar vortex and the wet weather comes in. Look, when we were in 1993, my son was born in 93, we had a blizzard here in Atlanta. And it was like, a foot of ice and snow. Hadn't happened since, but it could happen. It can happen. So I don't know. I think, I just think the weather patterns can be unpredictable. I think obviously some people feel there's a climate change element to it. I think sometimes it's just the weather patterns are crazy. I mean, who knows? Who knows? Everybody, what is the old saying? Everybody talks about the weather. Nobody does anything about it. Okay. So X-Ninja says, I just applied for SSD. I have 40 credits, been working for 20 years. I'm 34. Honestly, the big issue here is your age. 34 is really hard to win because that is considered to be a younger individual. And most judges are going to give that a really, really hard look. I mean, you're going to have, I would say, if you think about it this way, the younger you are, the more evidence you've got to have. As you get older, the amount of evidence you need to win starts to even out. But at 34, you're going to need compelling, overwhelming evidence. How long is it going to take? You're not going to get approved most likely at initial or recon. You're going to be looking at 2.5 years. And by the way, one thing I would tell you at 34, this may be a situation where you may want to try to work, see if you can get some, failed work attempts in there, get statements from former coworkers, get your doctor support. You're going to need you're going to put every tool in every arrow in the quiver, as it were, to win at 34. This is Lucky Southern Girl says, I don't want to take Medicare since I've got private insurance. I'm not a Medicare person, so I'm not the person to ask that. The person I ask my Medicare questions to is a gentleman named Cal Hero, Hero. He's got a website called Medicare Mall. Cal is in the insurance business. I'm going to tell you flat out. And he does sell Medicare supplements and all these kind of things. But he's also been very, very gracious in answering questions like this, where it wouldn't put any money in his pocket. There's nothing he would sell you, but he would answer that question. info@medicaremall.com, info@medicaremall.com. Just tell him that you're one of my listeners and you have this quick question about, can I turn down Medicare? And he could probably answer that for you. Might even, again, this is another thing, go to ChatGPT and ask it and see what it says. Chan Tet, one of the another longtime viewers, 50 years old. My hearing's next week. Please leave a tip for hearing advice to ask my attorney. Thank you much. I would say, Chan, what you want to do is talk to your attorney and ask the attorney to give you, if possible, a list of questions that you're likely to see, and then practice those questions. I did a video that talks about certain questions you're going to get at every hearing, if it's physical, let's say, or mental for that matter. So those questions should not be a surprise. So if you've got a physical problem, you're going to be asked how long you can stand, how far you can walk, how long can you sit, how much can you lift, can you get down on all fours and get back up? Do you need an assistive device? Do you have problems reaching overhead? How much can you lift frequently? How much can you lift occasionally? Again, 1/3 of the day, 2/3 of the day. Any trouble getting dressed? Personal care? Do you have to take unscheduled breaks during the day to lie down? There are just certain questions that you're just going to get every single time. And I think your attorney should give you those questions, and you should practice them. So, for example, I talked about this earlier, how long can you stand and walk? When there are two different functions, by the way, the standing. So let's say standing. So I ask the question, if you're at the Department of Motor Vehicles, you're standing in line, you can't lean on anything, how long could you stand before you'd have to just give up your place in line and sit down? Any one time. How long would you have to rest before you could stand again? How many times could you, let's say you said 20 minutes. How long could you repeat that cycle of 20 minutes on, 10 minutes off, 20 minutes on? What is the total amount of standing you can do during the day? Have those questions prepared so you can answer them. Walking, how far or how long can you walk? Don't say not very far. You might say I could walk about 10 minutes. And then I become, the pain in my back becomes so severe, I've got to sit down. Going to the mailbox, I can get there. I hold on to the mailbox for a couple minutes and walk back. And that's about it. I can't walk on uneven terrain. There's a multitude of questions, and not all of them are going to be relevant to every case, but ask your lawyer to go through all those type of things. Ask your lawyer, what is his or her working theory of disability? Are they arguing for a grid rule? Are they arguing functional capacity? Are they arguing a listing? What is the argument they're going to use so that you understand what that argument is so that your testimony fits in? If you're arguing grid rules, then you might want to talk about, getting rid of transferable skills by your confusion, by your inability to focus, that needs to be emphasized during your testimony, because your testimony is evidence and judges will listen to it. So just want to have a big picture of what your lawyer's doing. I like to do a brief. I mean, I personally have gotten to be, that's just something I just now do on almost every single case. And the only times I wouldn't do it would be if it's a case where it's a weak case and the brief is just going to emphasize it's a weak case. And I just rather take my chances with an opening. But a brief really spells it out. And my client looks at it and I can say, this is what we're going to talk about. So let's make sure we're on the same page there. But I think that would be it. And I'll sound like a broken record. The main thing is when you're testifying, eliminate from your vocabulary. Eliminate from the vocabulary, not very much or not very long, not too far, not very, I just piddle around, don't do much of anything, not so often, not very, eliminate those phrases. They don't mean anything. You want to be very, very specific and talk about, 10 minutes. I take a pain pill and for an hour and 45 minutes, I am a zombie. You want to be very, very specific. You want to make sure that you, give those answers in those very, very specific terms. And as I mentioned before, which my client Tom had done, write some of these things out, write some copy points, have it in front of you so that if you get nervous, you can look down and you remember, okay, this is my lifting and carrying and walking and things like that. And, you can review that ahead of the hearing so that you're on the same page. But I think really the biggest thing is your lawyer and you should go over it. I usually spend more time, if a hearing lasts 45 minutes, I'm going to spend an hour and a half doing a pre-hearing call to make sure that, not always, but a lot of times, make sure my client has everything that they need to, answer these questions effectively. Okay, let's see here. Is this live? No, this is live. I'm doing this. It is now 10:06 p.m. Eastern Standard Time on February 4th. So I'm doing this live. I do record these and I put them out on my YouTube channel, so somebody could view it. And what we're also doing now is I'm taking bits and pieces of these and I'm chopping them up and making other videos of them. But I do these live every Wednesday night at 8:30 Eastern. So please tune in. Okay, I have a 1947 GMC. It's a hot rod. First vehicle, love it. Everyone sees it, loves it. As moving way too fast about that kind of thing. Possibly. As you mentioned the GMC, the 47 GMC. One of the things I really like to do is old car shows. I'm a photographer, and so I'll go to old car shows and take some really neat photographs. There's actually also up in north of Georgia, there's like an old car graveyard. I don't know if you've ever seen one of those, where you have a bunch of these old cars. A lot of them are just kind of rusty hulks of things, but it's kind of interesting to see the design of cars from the 40s and 50s and things like that. But cars, at one point the designs were a little over the top, but they were real works of art. And even like the hood ornaments were kind of cool. So having an old car like that would be kind of fun. I have my buddy across the street, who I grew up with. He's got I think a 60s or 70s, I don't know, Monte Carlo or something, and he had it restored. And he actually, two buddies of mine, they own it together, and so they take it out on the weekends. And it doesn't have air conditioning. It smells like gasoline. I've been in it a couple of times, but people definitely see it and they look at it and they point at it and everything. Is kind of cool. So don't have one myself, but I don't know that I really want to be spending a lot of money on refurbing an old car, but it'll be kind of fun to have. I think maybe at some point, if I ever get to that point where I got nothing better to do, I'll do it. Okay. Okay. So you're getting SS retirement at 64, and you applied at 65. For me, I know you'd asked me this question before. There's probably not enough difference between the early retirement money and the disability retirement money that would make it worth my while, because I get paid 25% of past due benefits. If the past due benefits $100 a month, and it takes a year, $1,200, 25% of that, it's not worth it for me. Now, other people might see differently, but not for me. Do I think AI will replace adjudicators? I think All right, 4 o'clock lover says, do I think AI will replace adjudicators in processing disability claim applications? I think that what will happen is there will always be a senior level of adjudicator, like supervisory type of people. But I think that a lot of the adjudication work, if you ask me this, if you look at this 4 or 5 years from now, will be done by AI. Yes. I think there'll be somebody who has to look at the work, look at the AI adjudication. But yes, that would be a function where there's enough data where they could have and they may train the AI to be overly critical, overly demanding. But yes, that would be an area where I think humans will be replaced by AI, but there will be a human supervisor, over a certain number of these AI tools to check the work. That's what I think. Okay, and AI, that's true. Look, no question that there are jobs that AI can and does do that humans don't need to be done. Look, I have a buddy of mine who's a CPA, a pretty high level CPA, does tax work for not Fortune 500 companies, but large companies, and high dollar type of stuff. They don't use AI, but they use folks in India to do the tax returns, to draft them up. It's done at the prices, like 20% or 25% of what it would cost to have somebody here. If they can't even find people here, they can't find entry level, accountants. So they have people in India do it, and they have computers, as I understand it, they have computers that the person can't download anything. They only can get what they only work on the computer there. There's all kind of safety, safeguards to protect privacy and so forth. And what my buddy tells me is, they get these things back and they're, 75 to 80% correct. And then they have a senior person review them and make the adjustments. But he says it just, they have no choice because they can't find people to do it here. But he's like, it is a huge time and money saver to have a lot of this stuff done. So I think that there are going to be, humans being replaced. And I think AI will eventually do things like that. Whether it will be able to do tax returns, I think it probably will be at some point. It can already write a brief. Is it going to be 100%? No. But the way I would explain it is this. I've done this a long time. So when I prepare a case, there's a certain protocol I go through. I have a worksheet that I work out of, information I've got to have in front of me. If somebody called me up and said, I have a hearing in 2 hours and I got to have a lawyer, can you do it? 10 years ago, I would have just said, I don't have time. There's no way I can get ready in 2 hours. Now, if I had all the data, all the information, the file, I could plug it into an AI tool. I could get back a summary enough where I could go to that hearing and at least do a serviceable job. Maybe not as good a job as I would do if I had normal amount of time, but I could get up to speed pretty quickly. And the rest of it would be based on I've done this a long time, so I kind of know what to do. But yeah, it gives you a real leg up on getting things done a lot more quickly. And it just saves a lot of the grunt work out. I mean, I look at medical records. I was looking at one the other day, 4,000 pages. That's a large medical record. And a lot of it is duplication. Some of it's hard to read. There's an AI tool that I use that is, again, it's a HIPAA certified closed system. It's not Notebook LM. It's a different one. It's a paid one that I paid, a decent amount of money per month for. I plugged it in there and it gave me a very, very nice summary. I had to go through and double check it and make some changes. And I had to look to where it was referring to, and there were some mistakes, but by and large, it gave me a very nice summary. So I'm able to talk to my client intelligently about medical, and instead of going through 4,000 pages, which would have taken me, 3 or 4 days, I'm able to get up to speed in about 45 minutes. That's what AI can do, at least for me. Okay. So, so it's going to be different for everybody, but I think it's a great tool. Okay. Hope it works out. Yes, I hope so too. Elise says SSA has a basic AI system. She was part of the work group. It's not advanced enough to issue decisions. It's not now, but it will be at some point. We'll talk about that a little bit more next week. Okay, we are, let's see where we're at time-wise. We got about 15 more minutes here. Elena Ladd, turning 55 soon. Well, early happy birthday. Alabama, stage 3 DBS, very symptomatic. I got some of this heart failure with reduced ejection fraction, autonomic dysfunction, major depression, prior work, fast-paced cognitive on 3 monitors. The fact that you're symptomatic on meds, that's going to go a long way. Turning 55, I would say, the odds of getting an approval at 55 are probably pretty good. Whether you get them, if you allege an onset date before 55, that may be a little more difficult, but I think it's probably a winning case. The fact that you're symptomatic on the meds, that jumps out at me right there. Autonomic dysfunction, which means that you're going to be, have some balance issues, and standing and sitting are going to be an issue. I'm assuming that you're talking about heart failure with ejection fraction. That's also going to be that's going to be create functional limitations. You had fast-paced work. It's probably not going to happen anymore. The depression, I think that you probably can get rid of past work. It smells like a grid to me. Smells like a grid or a functional capacity, probably a winning case based on that. Again, this is an example of somebody gives me fact pattern. I can say I would want to look at the medical record, but based on what you're telling me, probably would take a case like that because it sounds like it's got some strong elements to it. Current client of mine in the recon stage, moved from California to South Carolina. They want to see if you've established care yet. How long do we hear? Once it goes into South Carolina from California, it's got to be assigned to somebody there. They'll use the work that was done in California. I would say, you're probably looking at 6 to 8 months once it's transferred over without, knowing the exact details. What was done in California, how much the file was done, the fact that your treating is good, that won't slow things up a little bit. So I'm going to give you a rough ballpark, 6 to 8 months. And could it be an approval without a hearing? Could be. Absolutely could be. Again, it depends on, age. It depends on the nature of your condition. Is it a grid rule case? Is it compelling functional capacity case? I was, and now what I'm doing, this is again another use for AI. I'm pulling down medical records early, having an AI review, then using that to write kind of a mini brief. I'm getting more cases approved early, so we can certainly do that. If you don't have to say who you are, obviously, in a public forum here like this, but email me and let's go through what we can do to try to move things along a little bit, because I love early decisions. Well, I'm glad that we are quick. Thank you very much for tuning in. James, didn't I represent you? I think I did. Because your name sounds very familiar to me. This might have been a case I did for another attorney, another rep. I handled the hearing, but I pretty much think I did work with you. And I'm almost sure. I think you had a birthday recently too, because I have I always put birthdays on my calendar. I think yours came up recently. So anyway, but hello, thanks for tuning in. Karen says, do SSDI cases have to go to a judge for decision with a solid case? Grids can be approved? Yes, that's why I do pre-hearings and pre-hearing briefs, because I will give the judge every reason we can to approve the case early. And sometimes they do, and sometimes they don't. Some judges just want to see you or hear from you. Other judges, I've had a number of judges, if we get that pre-hearing brief in early, they'll say, we're going to go to issue it on the record. I'm like, okay. That does happen. Can Social Security change a patient's diagnosis in order to pay them less at an ALJ hearing? they can't change your diagnosis. What the judge could do would be to change or to make a determination that your functioning is more robust than what you say it is. So a judge, the doctor may say, that PMF can only walk for 15 to 20 minutes. The judge could say, based on my review of the record, I think he could walk for an hour. That could be challenged and appeal, but a judge could find some of the evidence not compelling. And realize one of the things that Social Security did a number of years ago was they eliminated the treating source rule. Used to be, if you had a treating source, somebody you had seen extensively for months or years, that person's opinion, that doctor's opinion, would be given controlling weight. And a doctor you saw one time for a consultative or a non-examining doctor that you never saw would be given much less weight. Well, Social Security got rid of that. So they can deny a case, or they can rely on the findings of a doctor who never physically touched you or met you. Most judges aren't going to do that, but it's allowable. So that is one of the things that we have to deal with. So yeah, judges, if the judge wants to deny, look, and again, I'm interested to hear Elisa's take on this, but judges are human beings. And if they think you're not truthful or not credible, they can say whatever they want to say. They can deny you. They can basically, they don't believe you. They'll find they can't say and find you credible. That's no longer allowed. They can't do that, but they can just say, they think that your symptoms, the way you're describing, are out of proportion to what the medical evidence says. And those are hard cases to win an appeal because, certain findings of a judge, the appeals council is not going to overturn. So if a judge really wants to deny you, there's ways they can do it. Great question, Karen. Does SSA review a person's social media accounts? They're not supposed to, but I think they do. So I always tell people, put it on private, at least until we're over with this. I had a case last week where I had a person who had a very active social media presence, had traveled internationally, was eating showing pictures of all these very interesting foods that he was eating, which I would not eat, but he was eating all kind of crazy stuff. And one of the issues he was talking about, which I think is well documented, are some digestive issues. Now I don't know for certain that these things are hard to digest that he was eating, but they were, in a foreign country, things that we don't see normally in the US. He's from a different country. They were normal to him. But I just said, why take the chance? Put it on private. He did. It was never mentioned. But I think that, a judge is going to possibly do a quick look to see, because if a person's complaining of back pain, I remember a case I had years ago, had a woman who was complaining about severe back pain. She was obese. She was, 75, 80 pounds overweight. You look at her Facebook page and there's pictures of her climbing a climbing wall, and I'm like, what in the world are you doing? Get that off of there or put it on private. She never did. She got denied, wasn't a great case. But I mean, if I'm a judge, and even though I'm not supposed to do it, and I do it anyway, and I see a person on a climbing wall and they're saying they got severe back pain, picture's worth 1,000 words, So I would say, Karen, put it on private. Now, if you've got a business, and this is a whole different issue about, what involvement do you have in the business, et cetera, that's a different story we can talk about. But I think for just personal stuff, your Facebook, your Instagram, just put it on private. It's just nobody's business. Nobody's business. Mr. Fix-It, my onset was October 2024, and I was 54. My first hearing is coming up, turned 56 in April. A lot of times what judges do is they'll find you disabled as of your 55th birthday. And assuming that there's no date last insured problem, you may have to make a decision. Do you go with that or not? But, it may be they approve you at 55. I've had a lot of cases like that where I get an approval, but they change it to the 55th birthday. Felicia, denied twice. My Zoom course approved for SSI. I have to wait 10 days for full approval. Okay, so you had your ALJ hearing by video. You're approved for SSI, but have to wait 10 days. I'm not sure why they would make you wait 10 days for SSDI. But it sounds like you're on the way to being approved, which is good. What is the purpose of doing a CDR? Asked Calbo. To have an in-person medical exam, the consultative, because Social Security wants to see, wants an opinion about your functional capacity, and having a independent, doctor do that is one way they can develop the record. I don't know how independent all of these doctors are, but that's part of what they do quite frequently. How do I think that, again, Mr. Fix-It, without knowing the medical there, again, I would say talk to your lawyer about, does it make sense to take an onset at 55 and make this thing go away, or do you want to fight for what I do in those situations? I'll say, my client, let's continue arguing for an onset at 54, realize the judge may offer you an opportunity for a favorable decision at 55. What do you want to do? Let's talk about it now, as opposed to talking about it at the hearing. And so if you say to me, okay, I'll take 55, knowing it's going to cut my past due benefits, but a win's a win, I'll say, well, Your Honor, we talked about this possibility, and based on my conversation with my client, we're prepared to amend the onset date to the 55th birthday. Or, Your Honor, my client and I talked about this, and even though we realize that 55 is kind of a threshold birth date, we feel the evidence is strong enough that at age 54 in 2 months, this person was in fact disabled. Or we think that at age 54 and 7 months, it's close enough to 55, we'd ask the court to use that date. There's a couple ways to do it. That's that rule that says if you're within 6 or 7 months of the next birthday, you can use that grid rule to win, to give an approval. Okay, got time for a couple more questions. Steve Whitaker, will an FCE help my case? I'm 57, lower back damage. Doctor says my work days are done working with Madeline. She's been great. Yes, she's a rock star. Madeline is a rock star. Madeline, if you're there, don't get cocky, but you are a rock star. You're great. I think we probably have enough, Steve, but FCEs always help because they are a formal FCE, which would be by a physical therapist. Takes a couple of days. It may cost you $1,000. That's going to really be definitive. I don't know that it's all that necessary. 57, significant back issues, support from your doctor. We can look at it, but I don't know that it's really necessary. I don't know if I would spend the money. But, some people feel like they want to really nail it home, and that's what you could do. Mr. Fix-It, I saw your question. I'm trying to rush through some of the other ones. But again, yeah, I think that you might grid out at 55 or within 6 months of 55 or so. If this Kathy Clayton, if the CE doctor notes my limits in standing and sitting are no longer than 10 minutes, grip strength weakness, will this help? 61 and 38 years, yes, it will definitely help your case. There's actually another PALMS regulation that talks about 30 years of arduous work, and that works in your favor. So I think being 61 is a really, really important, helpful factor. That will make your odds of winning much stronger. That will really be helpful. Spinal stenosis, yeah, I think that sounds like a pretty good case. Tally, hello, how are you doing? Eunice Soa, comes here a lot. Good to see you. Thank you. My pleasure. Thank you for tuning in every week. I know you come most weeks, and good to see you. All right, got time for a couple more. Tony Hooks was denied at ALJ. RFC was less than sedentary. RFC means residual functional capacity. And there were jobs out there you could do. How can you do less than sedentary? You're 49 at the time of denial, be 50 in October. Well, again, the judge has to find, if you're found at less with a functional capacity of less than sedentary, you should win. So obviously the judge found that you have capacity for sedentary work. But if that was what the judge found at 50, you would grid out probably. So this is one of these situations where the difference between 49 and 50 can be fairly significant. So, that's why it's harder to win under 50 than, over 50. The stock XJ. Glad I came across this. Somewhat stimulating versus the run-of-the-mill political stream where it's chaos. Yes, I try not to be chaotic. Some have said otherwise, but yeah, I like to share what I know. This is it's fun for me. Get some really good questions, and it's just I have a good time with it. So I started doing this about let's see, May of 24, I think. So I have a good time with it. Um, Tony Hooks, would this be a case? Tony, I'm gonna have to go back to, I don't remember your question, but if it's past the appeals council, possibly. They don't, federal lawyers, federal litigators don't take every single case that comes across. They got to make sure it's worth their while as well. Had to remove many streams. Yeah, social media, honestly is toxic. I mean, I have to be on it because this is what I do. YouTube, I kind of like because there's a lot of good stuff on YouTube, constructive things, but Twitter, what a cesspool. I mean, I post to Twitter automatically. I don't really ever get on it, but it's a cesspool. A lot of hate speech, a lot of talking to the echo chambers. Terrible. Facebook is a little bit better, but to me, maybe I'm old school, but if I'm not going to say something to somebody's face, I'm not going to say it. And to make political comments. Yeah, I mean, there are politicians who are not very honest, clearly, and some of them are pretty bad. But I think there are many who have their heart in the right place, get a lot of they're tugged in a lot of different directions. But, to sit there and say this person is, evil, or to say this person is, this, or Jeffrey Epstein is that. I mean, Jeffrey Epstein is a scumbag, but my point is that, if a politician, I saw, again, I'm going to get off my soapbox here. There's a doctor named Peter Attia who has a very, very interesting and well done podcast. And he speaks a lot. He talks about longevity and health and things like that. He shares a ton. He's written some books. He shares a ton. Well, about 10 years ago, he had an email exchange with Jeffrey Epstein. And basically, he just said, I can't believe I'm talking to you. You know everybody. You're so well connected, blah, blah, blah. Kind of a fanboy kind of thing. And he readily admits that he would never have done that today. Well, okay, he didn't go to the guy's island. He didn't do anything improper. He just had he was sort of starstruck maybe by this guy, and all the people he knew. And so he's being canceled. He lost his gig with CBS. He lost this, he lost that. I don't know Peter Attia from a hole in the head. I've listened to his stuff. This guy puts a lot of his knowledge out there. He didn't deserve to be canceled because he had an email exchange with Jeffrey Epstein, but that's what social media does. And that's the problem with it. It's just people say stuff or take positions they would never in a million years take in somebody's face. And I guarantee you that if you met Peter Attia and talked to him about, medical issues, you would be as impressed as I am about his knowledge. But the fact that he had an email exchange with Jeffrey Epstein 10 years ago, for a couple of days is causing all kind of problems. Ridiculous, in my opinion. Okay, I'm going to take time for one more. Christine always says, like, share, and subscribe. Thank you very much. Let's see here. Please leave a 5-star. Got to put that in there. Absolutely, leave a 5-star. Okay, I will answer. This will be the last question because we're at 2 hours now. Do all attorneys say they think the hearing went well? Would he actually tell me if it went bad? That's a tough call because you know what? I will say to my clients that I feel like we get everything out I wanted to get out. I have been wrong enough where I think it didn't go real well and I ended up with an approval. That happens 2 or 3 times a year. So I always say, if it's difficult, if it clearly it's not going to go well, I'm going to say, look, the judge, I don't think believed you. I think based on the questions he asked, based on his approval rate, I think it's probably not likely you're going to be approved, but let's wait and let's get the decision. We can look at it for appeal. But I always try to be optimistic that we presented a strong case. But yeah, I think you got to be honest. And if it didn't go well, and if clearly the judge's questions were, every question he asked of the vocational witness got all these different jobs, and he was hostile, or he's got a 20% approval rate, yeah, I'm going to tell my client it probably is not going to get approved. Just honesty, that's my take. Others may disagree, but like I said, I would caveat that with, I've been wrong before. I had it happen late last year. I had a case I didn't think went particularly well. The judge was not really nice. Get an approval. Okay. Had it happen the other way too. Everything seems like it was going well. The question gets a denial. But it does happen. So I always say, until we get the thing in the decision in black and white, we don't know. So anyway, all right. I think we are at 2 hours. I'm going to end this. You can tell I need my beauty sleep very, very badly, which I will get. I hope everybody has a really wonderful weekend coming up. You stay warm. Next week, again, Elise Enton will be here. Elise is somebody I've gotten to know recently. She's a former staff attorney with Social Security, has a lot of insight about how things work there. I think will offer some really good insight about the disability process, the type of cases that move the meter. And I'm looking forward to hearing what she has to say. So I hope you tune in and join us next week, 8:30 Eastern, same bat time, same bat channel. We'll see you then. Take care, everybody. Bye-bye.